Hi everyone. So, as part of tort law, what I'm going to talk about here are economic torts. So, there's a few different ones that relate, I suppose, to business and hence are called economic torts. So, some of the main ones you're likely to come across are passing off, which is sort of similar to the idea of trademark protection, but under the common law and hence under tort. Inducing someone to break a contract with someone else, fraudulent statements, injurious or malicious false statements about somebody's business, and conspiracy being another one, conspiring to injure. So we'll have a look at some of those. So passing off there is a tort committed by a person who, in a manner calculated to deceive, passes off his goods or business as those of another. So, we're going to bring out sportswear called Hike with a tick on it, uh, in the hope, calculated deliberately to deceive people into thinking it was Nike or something like or Nike, but we'll spell it with two E's and use similar packaging and get up and so on. So, obviously, if somebody has a trademark registered for their product, they can use that trademark legislation as protection. But even if they don't, they could still bring a passing off claim under the common law. Um, and as I say, it's to protect your product or business, or even in some cases, your own personality rights. So Eddie Irvine, the former Formula One driver, he took a case where an image or something of him was used in some promotional thing without his permission. It might have been Talk or Talk Sport or one of those. I can't remember now off the top of my head exactly. It was a UK case, but it was along those lines. The key elements of the tort passing off would be you have to establish that you actually have a goodwill built up in the product in the first place. Another party can't damage your goodwill unless you can actually show you had a goodwill. So reputation, if you like, a good reputation. There has to be some false statement by the other party. That's where the calculated to deceive comes in. And then obviously this must result in some damage or injury to your business, usually financially. Um, so some examples, there's lots of examples. A lot of the cases obviously are brought for both passing off and trademarks because if you have a trademark, it doesn't prohibit you from adding the common law claim of passing off to your legal claim if you are suing. So you sue for trademark infringement and passing off. So a Jemison case involved whiskey, John Jemison and maybe a James Jemison, which one had established the reputation in the word Jemison's for whiskey, would have been the thing. The Griffin case involved a Rosslare Hotel and a Rosslare Strand Hotel. So again, one hotel existed, another one was built, and the existing one, which had built up a reputation, was worried about damage to its reputation by the new hotel. Buy and sell an auto trader, again, one of the things with deceiving, I suppose, is causing confusion. So would there be some sort of confusion between buy and sell or auto trader if you were thinking of buying a car as a customer? And of course, buy and sell deals with lots of different things, not just cars. So you probably wouldn't pick up buy and sell instead of auto trader. You wouldn't mix them up. Guinness against Kilkenny related to Guinness having established a goodwill in the beer called Kilkenny, although there was another brewery in Kilkenny itself brewing a beer that they wanted to call Kilkenny beer. CNA Modes was sort of fashion retailer that operated in the UK, including Northern Ireland, and a store was open called CNA Modes in the Republic, I think actually in Waterford. Um, Pretty sure it was in Waterford, and obviously there was an issue then with using that name. Polycell was a cling film type product. So cling cell, polycell sound very similar products. You can see how to be an issue there. A United Biscuits case. Somebody wanted to bring out biscuits called college creams, and there was issues that you might mix them up with cottage creams, and they might be of an inferior quality, and therefore that would put you off to cottage creams, and you'd be affecting the revenue also of the biscuit manufacturer. So in player wills, whether or not players had established a reputation in a brand of cigarettes commonly known as blues or John Player Blues. The Mitchelstown case then was the butter case, where would you mix up DZ Gold, Dairy Gold, Dairy Gold and Easy Gold there, I got mixed up, Dairy Gold or Easy Gold if they were in similar tubs with a similar type of yellow flower on the front and so on. So a lot of detail goes into these cases at times, looking at the shape of the packaging, the colors used, images and graphics and text, and down to the font type and the type of picture and so on, in order to try and prove and ultimately win a case. And Adidas took a case against O'Neill's, the Irish sports wear manufacturer, for having 3 stripes on their, usually it's on like tracksuit pants and stuff. But O'Neill's actually won that case. The court felt that putting 3 stripes on an item of clothing in itself wouldn't amount to interference with Adidas's reputation. Adidas, of course, coming from the names Adi Dassler. So the guy who formed Adidas was called Adi Dassler, and his brother, another German, set up a competing sportswear company. So there's something if you want to look up about his brother, called Rudi Dassler. So that is actually true. 2 brothers selling sportswear and in competition with each other, with 2 famous brands of companies. Another tort then is inducing a breach of contract. So this is where a person knowingly and without lawful justification induces somebody to break an existing contract with a third party. So in Lumley against Guy, a singer was contracted to perform in an opera, and another opera coaxed her away, if you like, to go and sing for them. So they caused her or induced her to break the existing contract that she had. Now, look, there are other similar things to that, and Lumley against Guy in some cases are old. So I mean, there is a possibility, and sometimes in modern law, if you like, or legal thinking, that you could have a contract with somebody that's so oppressive that it would be okay to allow them to break it and so on. There are cases similar to that involving, I think, Betty Davis and actresses and so on, and movie companies. So we'll take a look as what happened in that case, but just be conscious that if it's an older case around something like that, that times and circumstances might change, and the court might always find exactly the same thing. Interference with contractual relations, excuse me, are known as tortious interference. A few examples there: the Cooper case, where a trade union interfered in an employment contract. So you could imagine you have to be careful with industrial action, that it's lawful, otherwise it could be considered interference with contracts, or indeed it could be amount to conspiracy. In the old days, there was lots of opportunities to bring conspiracy cases against unions. We'll talk a bit more about that soon enough. In HB against Mayors, company was a tying arrangement. So HB gave HB ice cream freezers to all the small shops, or a lot of small shops, but there was a catch. You could only put HB ice cream in it. Mayors went along, came out with their Mayors ice creams, and they went to the shops, and of course there was no room for another freezer because shops, particularly back then, were smaller. So they decided that the reps told the shops that it was okay with HB to put the Mars ice creams in the HB freezer. HB didn't agree with this, and they brought a case over it. Douglas against Hello then involved the Douglases. So Douglas, was it Michael Douglas? I think was his name. It was marrying Catherine Zeta-Jones, who I think was in the Zorro movies. So two big actress celebs having a wedding. So they were going to make money out of the wedding. They weren't missing an opportunity. So they sold their wedding photos to a magazine. So there was two magazines involved. I'm not familiar with them. I haven't read them myself. I'm not even sure if I saw them in the doctor's surgery while I was waiting. But one was called Hello. Obviously, it doesn't name the case. The other was called OK Magazine. And what happened is the competing magazine infiltrated the wedding and got someone to take pictures. And they ran the pictures of the they ran the pictures of the wedding before the Douglases could sell them to the magazine they had made a contract with, which meant the Douglases were out of pocket because the story was no good anymore. So they brought a case. Fraud then is obviously a person deliberately deceiving another person causing damage. So in the Freeman case, the claimant was told by the defendant that a person was creditworthy, even though they knew well he was broke and wasn't creditworthy. So they loaned money to this broke person who couldn't repay it, and they suffered a loss, and they sued for fraud. So obviously fraud being based on deceit, having a sort of an intention to deceive, is difficult to prove, but you will come across in contract law, particularly the concept of fraudulent misrepresentation, a false statement of fact. It's knowingly deliberate to get somebody to make a contract, for example. If injurious and malicious falsehood, then making false statements designed to injure somebody as regards their trade or business. So it's basically slander against a business. It's different from the deceit because the falsehood is addressed to the person who acts on it to their loss, whereas the injurious falsehood was directed to a third party who acted on it. There's also a malicious falsehood rather than injurious. So this again is deliberate false statement, trying to cause damage to somebody's trade or personal reputation. It's covered now under the Defamation Act of 2009, and there's a link there to the section 42 of the Act. So that should be in your notes. Conspiracy then, I mentioned, was a tort whereby two or more persons can act together to cause a loss or damage to another person's trade or business without lawful justification. And that's very important there because many years ago, this would have been used against trade unions when they'd go on strike and all, say, well, sure, calling a strike is two or more people acting together to injure the company. But obviously, if it's a lawful industrial action, then you're okay. And it could either be an unlawful act or a lawful act done by unlawful means. As I said, it's two or more persons acting together. And today, most union activities will be lawful, so they'll be exempt. There is a case in 2000 involving Earnode Aaron, however, which you could, if you want to look up on the Bailey website, just to see what it said about conspiracy, if you're interested in a bit more depth on it. But it's the idea of the union calling industrial action, which meant that trains wouldn't run. Another fairly recent case is Sheehan against Breccia in 2020. So that's a bit about economic torts and torts that are designed to injure businesses and business reputations.